All right, is the state ready to call this next witness?
Your Honor, Anderson County will call Mr. Larry Greer.
Excuse me, I said state, I mean county. I promoted you, I guess. Promotion. Come forward, sir. I'll let you decide whether that's a promotion.
Right here, please, sir. I could ask you to raise your right hand. Do you solemnly swear or affirm the testimony you'll give the court today in this case to be the truth, the whole truth, and nothing but the truth? If you would take the witness stand and state your name for the record and spell your last name for the reporter, please.
My name is Larry E. Greer, Greer.
Good morning, Mr. Greer. Can you tell the court where you currently reside?
1300 U.S. Highway, Anderson, SC.
And you agree you went to college at Clemson?
I do.
You have a bachelor's and a master's degree in agricultural education from Clemson?
I do.
After you graduated from Clemson, you worked as a teacher for 30 years in the South Carolina school system, is that right?
That's correct.
And you retired from teaching in 1999?
June of 1999.
You became an Anderson County Council member on January 1st of 1999, is that right?
That's correct.
During that time, you served on the council from January 1 of 1999 until December 31 of 2008, right?
That's correct.
During that time, you served on the Economic Development Board for a period of time?
Sometimes, yes.
And when you served on that board, you agree with me that you did not travel on behalf of Anderson County, did you?
I didn't do any travel outside the state, let's say.
And you served as chair of county council for 2 different periods of time, is that right?
That's correct.
Michael Thompson was the chair of county council in 2008, is that right?
That's correct.
Would you agree that you personally would not seek out county employment while you were serving as a member of council?
I would not.
That would not fit in with your values, would it?
I was not seeking employment with Anderson County then nor now.
At the council meeting on November 18th of 2008, you agreed that you voted in favor of Mr. Preston's $1.1 million severance package, is that right?
I did.
And at the time you voted in favor of the severance agreement, you did not know that Chairman Michael Thompson was seeking employment with the county, did you?
I did not.
You first learned that Mr. Preston was making a claim against Anderson County concerning his employment back in September of 2008, is that fair?
Somewhere along that time. I don't remember dates specifically.
Would you agree with me that you first learned of it when you and other members of council got a letter from Mr. Preston's attorney, Rob Hoskins?
I believe that's correct.
So the date of that letter is the date that you first learned it, is that fair?
The date of the letter may not be the time I received it, but that's the approximate time.
Would you agree with me that that letter that Mr. Hoskins sent on Mr. Preston's behalf talked about a claim for anticipatory breach of this contract? Is that
I
fair?
would.
And let me show you, if I may, if I can find an exhibit number 3 and a half, Roger.
You may. Yes.
Mr. Chair, I'm just going to hand you, it's already been admitted as plaintiff's exhibit 3 earlier in the case. Is that the letter we're talking about from Mr. Hoskins to the county council members?
I would say yes.
So sometime on or after the date of that letter is when you first learned that Mr. Preston was making a claim for anticipatory breach against the county. Is that fair?
To the best of my knowledge, yes.
And you agree that you took from this letter that Mr. Preston was complaining through his lawyer that he is going to be prevented from carrying out his duties as administrator, right?
Would you ask your question again?
I'm sorry, yeah. You agree with me, do you not, Mr. Greer, that you took from that letter that Mr. Preston was complaining that he was going to be prevented from carrying out his duties as county administrator at some point in the
Are
future?
you asking me if I took it from this letter alone or this was part of the
Yeah.
information and process that I used.
No, at this point, I'm just asking from that letter alone, since this is the first time you heard about a claim.
This is the first time I heard of the anticipatory breach claim.
Okay, and so would it be fair to say that you took from that letter that what Mr. Preston was complaining of was an anticipatory breach of his contract concerning that he might be prevented from carrying out his duties in the future? Fair to say?
That's basically what the letter says, I believe.
And by September of 2008, you would agree with me that the general election had not yet occurred. Fair to say?
It had not.
And at this point in time, September of 2008, there were certain individuals, including Eddie Moore, Tom Allen, and Tommy Dunn, who had won their primaries back in June, but would not take office until January of 2009, correct?
That's correct.
And those three folks would not officially be county council members until after those three folks would not officially be county council members elect until after the general election occurred in November. Fair to say?
Would you restate your question?
And I'm sorry, that wasn't the best question. When you win the primary in Anderson County, you're not elected to council, correct?
Not officially until the November election.
So at the point in September of 2008, when you received this letter from Rob Hoskins, you knew that Eddie Moore, Tommy Dunn, and Tom Allen were not going to be county council members until at least January 1 of 2009. Fair to say?
They would not be sworn into office until January 2009.
Your presumption would be that they were going to win the general election. Is that fair to say?
There was no doubt in my mind.
And that primarily because there was no opposition?
That's correct.
You agree that none of these three primary election winners, Eddie Moore, Tom Allen, and Tommy Dunn, could act in any official capacity for Anderson County before they were sworn in. Is that fair to say?
They could not take official action until they're sworn in.
Any newly elected council members from the 2008 election cycle would not have any authority to do anything on behalf of Anderson County until they were sworn in. Fair to say?
That's correct.
After this letter came in from Mr. Hoskins on or about September 25th, 2008, would you agree that the matter concerning Mr. Preston's anticipatory breach claim was referred to the Personnel Committee?
I believe that's correct.
And Mr. Greer, you were a member of that committee, right?
I was.
The other Personnel Committee members back in 2008 were Ron Wilson and Bill Mackey, correct?
That's correct.
Mr. Wilson was the chair of the committee at that time.
That's correct.
And the charge to the Personnel Committee back then was to take up the matter of Mr. Preston's anticipatory breach claim and provide a report back to council as a whole, correct?
To the best of my recollection, that's correct.
Would you agree with me that the committee never did provide a report back to council?
There was never an official report by the committee back to council.
Look, Mr. Davis almost did. And would you agree, Mr. Greer, that Mr. Preston was asking for more than $1 million from the county as part of his claim?
I would.
That's a lot of money, isn't it?
Yes, it is.
This was a big deal for Anderson County, wouldn't you agree?
I would.
And it was important enough that county council hired an employment lawyer, Tom Bright, for the sole purpose of providing advice about the anticipatory breach claim. Would you agree with that?
We had an attorney to advise us, yes.
And you agree that Mr. Bright was an employment lawyer?
I do not
Don't
know that for sure.
Would you agree that Mr. Bright was hired for the specific purpose of advising the Personnel Committee about the anticipatory breach claim of Mr. Preston?
He was hired to advise the committee.
Advise the county?
The committee.
Okay, I'm sorry, the committee. And he was advising the committee about the anticipatory breach.
That's correct.
At the time Mr. Bright was hired, you did not know that he was an employment lawyer. Is that fair to say?
I'm not sure exactly what I knew about him. We had a brief synopsis of him, I think, that someone obtained from the internet.
Would you agree with me that Mr. Bright interviewed you before the Personnel Committee met to discuss Mr. Preston's anticipatory breach claims?
He talked with me on the phone.
Okay.
When it was, I have no recollection.
Would you agree that it was before the Personnel Committee first met about Mr. Preston's claim?
I can't agree to that because I'm not sure.
You do know that he did call you on the phone, and what was he calling you about?
He just wanted to get some input from me.
And I'm going to show you, if I may, and I'm not sure, Your Honor, if this is just a plaintiff's exhibit or if it's also a defense exhibit, but it has been pre-admitted as I understand it. We marked it as plaintiff's 19. I'm not sure if there's a corresponding defense exhibit.
Any objections, just refer to the document?
No, Your Honor.
You may proceed.
It's actually Keenan's witness.
No, Your Honor.
All right, thank you very much.
I'm going to hand you with the marked plaintiff's exhibit 19. And I'm not suggesting that you have seen this document, Mr. Beard, because I suspect you have not. This is a document that was explained to us as notes from Mr. Bright of his conversation with you back in October of 2008. And in this, it includes that Mr. Bright explained the proposal that had come from Mr. Hoskins. Do you recall Mr. Bright explaining to you that a proposal had been made from Mr. Hoskins concerning Mr. Preston's anticipatory breach claim?
I don't recall it, no.
You remember that he was talking to you in general terms about what? Background information about the claim or about the county?
To the best of my recollection at this time, it's been 4 years since this occurred.
Would you agree that one of the things you talked to Mr. Bright about was the fact that there were accusations out there that Mr. Preston was using credit cards for improper purposes?
I would say that would be a fair assumption, yes.
And one of the other concerns out there, and I'm not saying this was a concern of yours, but one of the other concerns that some county council members had was that Mr. Preston might be involved in impermissible relationships with county employees. Is that fair to say?
I had heard those rumors, yes.
And you were not aware, one way or another, if there was any truth to those rumors, were you?
I had no proof.
The Personnel Committee met 2 times, is that right?
That's correct.
And that was 2 times in the fall of 2008 to talk about Mr. Preston's anticipatory breach claim. Fair to say?
That's correct.
How long did the Personnel Committee meet the first time it met?
I have no idea.
Do you recall it being like a day-long meeting? Or
Oh, no, it's not.
Half a day?
It was probably hour, something like that.
about an hour or so?
That's a guess.
Okay. That's your best guess from
I
memory?
don't know how long it was. We met at the Powdersville Library, and I don't know. I don't remember when we started, and I don't remember when we ended, so I can't give you a time frame.
Would you agree with me that it was a meeting that occurred in the evening?
Seemed like it was in the afternoon.
So it was no more than half a day?
No, it's no more than a half a day.
Was it no more than a few hours?
Possibly, yes.
About that time frame, maybe?
Something like that.
And what about, did
He
you meet Ian?
indicated he wasn't sure at the time. Let's move on to something else.
The second time you met, do you recall how long that meeting was?
No, not really. Probably 30 minutes to an hour, something like that. Maybe longer. I don't know. I didn't keep a time clock.
Would you agree that no one kept any minutes of the Personnel Committee meeting either, did they?
Are you finished? Do you want me to answer?
Yeah, I was finished.
I'm aware that no minutes were kept, if that's what you're asking.
The first meeting of the Personnel Committee was in Powdersville, that's what you said, correct?
That's correct.
And at that meeting, the Personnel Committee members were present, along with Mr. Waldrop and Ms. Wilson, right?
That's correct.
Would you agree that Mr. Wilson was not happy with Mr. Waldrop and Ms. Wilson's attendance at that meeting?
Objection, Your Honor, that calls for speculation.
And I'll ask you
You
that.
can ask questions about what he observed and what he saw, but not what might be in someone else's mind.
Did it appear to you, did it appear to you, Mr. Greer, that Mr. Wilson was not too pleased with the fact that Mr. Waldrop and Ms. Wilson were in attendance at that meeting?
Same objection, Your Honor. If he's asking about body language or comments or something.
Yes,
like
if
that.
he appeared, that would be his observation. I'll allow that question.
Thank you, Your Honor.
Are you talking about his attendance or their attendance at the open part of the meeting or the executive session?
At the executive session.
At the executive session. Mr. Wilson, initially, I believe if my memory serves me correct, was going to exclude them from the executive session, and they debated the point, and Mr. Waldrop and Mrs. Wilson did indeed attend the executive session.
Did you have any opinion as to whether or not Mr. Waldrop or Ms. Wilson should attend the executive session portion of the meeting?
Did I have an opinion? Yes, I did.
What was your opinion?
My opinion was the executive session was only for the members of the committee and the attorney, and anyone else could be excluded.
So were you happy with the decision to allow Mr. Waldrop and Ms. Wilson to attend the executive committee's?
I thought it was inappropriate.
What happened in the executive committee session of that first meeting of the personnel committee?
To the best of my recollection, Mr. Bright presented information, and Mr. Waldrop and Ms. Wilson basically interacted with the meeting more than the members of the committee.
And your view of it was that Mr. Waldrop and Ms. Wilson engaged in too much conversation and discussion during the meeting. Is that fair?
And I would say that's fair.
And this meeting happened over the course of a few hours, fair enough?
I've already said I didn't know what the time frame was.
It was, okay. And after the meeting, a second meeting was held later on, correct?
That's correct.
Would you agree with me that in general terms, Mr. Bright advised the committee that he did not think much of the anticipatory breach claim brought by Mr. Preston?
He made those comments, a comment or several comments, whatever, that he was something along that line, yes.
And the second meeting that the Personnel Committee had was held in the large conference room of the Anderson County Courthouse.
That's correct.
And at this meeting, would you agree Mr. Waldrop and Ms. Wilson were excluded from the Executive Committee session?
I will agree.
The executive session, I'm sorry. Mr. Bright provided additional advice to the committee at that meeting as well, fair enough?
Yes.
And in that meeting, the advice of Mr. Bright also included advice that Mr. Preston did not have an anticipatory breach claim that was valid, correct?
That was part of the overall advice.
And fair to say you disagreed with Mr. Bright on that point, didn't you?
I did.
The sitting council in 2008, the one that you were a member of, was not going to fire Mr. Preston, was it?
No action had been taken along those lines.
And you were aware of no intention on the part of the sitting county council in 2008 to fire Mr. Preston,
I
right?
was not.
In fact, your county council, the 2008 county council, of which you were a part, was pleased with Mr. Preston's performance as a whole, right?
As a whole,
So you would agree with me, would you not, Mr. Greer, that Mr. Preston was not in any danger of a vote by the sitting county council in 2008 that would result in his termination?
by the sitting council, yes.
And the sitting council as a whole in 2008 never discussed the possibility of terminating Mr. Preston before he made his anticipatory breach claim, correct?
Did you say the sitting council
Yes.
as a whole?
Yes.
We had not.
And even if two members of council, Mr. Waldrop and Ms. Wilson in particular, even if those two members of council wanted to terminate Mr. Preston in 2008, you agree that there was no way they could do it because you had 5 votes in favor of Mr. Preston, right?
That's correct.
Now to talk about Mr. Preston's employment contract a little bit. Do you agree with me that the claim for anticipatory breach that was being made by Mr. Preston in September 2008 was a claim for anticipatory breach of his employment contract with the county?
That's correct.
And that's a contract you had reviewed several years earlier when you first served as chair of council, right?
That's correct.
You reviewed that contract because as chair of council, you had the responsibility to conduct an annual evaluation of his job.
I did.
In total, Mr. Greer, you agree that you read Mr. Preston's contract 2 times before you served on the personnel committee, right?
At least 2 times.
Mr. Greer, you don't recall if you reviewed Mr. Preston's employment agreement in connection with your work on the personnel committee in the fall of 2008, do you?
I did not.
You had a general working knowledge of the contract. Would you agree with that?
I would.
Do you recall one way or another whether Mr. Preston's employment contract with the county called for the purchase by the county of any retirement service credit for Mr. Preston under any circumstance?
I don't recall that being in there.
In your view, Mr. Greer, in the fall of 2008, you thought that if Mr. Preston was going to be unjustly terminated from his job, then the county should buy him retirement service credits. Would that be fair to say?
I did.
And you held that view regardless of whether the contract provided for such a purchase, right?
I did.
And for you, an unjust termination was simply a termination without cause, fair to say?
Among other reasons, yes.
And it's your view, Mr. Greer, that you don't think any public employee should be at the whim of an elected body.
I believe I said that.
And you stand by that statement today?
I sure do.
Now, you knew, Mr. Greer, at the time that you served on the Personnel Committee, evaluating Mr. Preston's anticipatory breach claim, that the county had the absolute right to terminate him at any time, as long as they paid him the severance called for under his contract, right?
State your question again, please.
Mr. Greer, you knew at the time you served on the Personnel Committee evaluating Mr. Preston's anticipatory breach claim, at that point in time, you knew that the county had the absolute right to terminate Mr. Preston at any time, as long as they paid him the severance called for under the contract, right?
Basically, yes.
In other words, as long as the provisions of his contract were met, Mr. Preston could be terminated at any time. Fair to say?
Could be terminated at any time.
Right.
Basically, yes.
Before the November 18, 2008 vote on Mr. Preston's severance agreement, you agree that you talked with Mr. Preston at least once or twice, correct?
I believe that's correct.
But you can't recall if you talked with him more than 5 times?
I don't know.
At least once or twice, but you don't know.
I think I said I know I talked to him at least once or twice. But
At least-
how many times, I don't know.
These were telephone conversations, right?
Pretty much, yes.
And during these telephone conversations, it was just you and Mr. Preston on the phone. Is that right?
Yes.
And during those telephone conversations, you talked with Mr. Preston about where you were going with the numbers on his severance package, correct?
Probably, yes.
And where you were going meant where the personnel committee was going. Is that fair to say?
Not necessarily.
Might have been just where you personally were going. Is that right?
That's correct.
So during these telephone conversations with Mr. Preston in advance of the November 18, 2008 meeting, you agree that you were discussing his anticipatory breach claim against the county, correct?
You're going to state that again.
So basically, you would agree then that prior to the November 18, 2008 meeting of county council, you had discussions with Mr. Preston about his anticipatory breach claim against the county.
I had discussions, I think I said, concerning maybe numbers.
And those numbers related to his severance agreement, correct?
Right.
And you thought it helped your decision-making process to have these conversations with Mr. Preston, fair to say?
No, I wouldn't say it affected my decision-making process.
Would you say it helped your decision-making process?
It was just a bit of the information. I would say it affected my decision, yea or nay.
You know, I'm at it. Offer the witness's deposition transcript to ask him about what he just said.
Sir?
You want me to bring this
Hand that
over?
up to him?
Yeah, I can hand him a copy if you want the original.
Hand it to me first.
Yes, sir.
Thank you. Record will reflect that I've been handed the original, what appears to be the original of the deposition of Larry Eugene Greer, as dated October 8th of 2012. It is a sealed document. Does the defense have any objection to my presenting this to the witness?
Your Honor, he did not waive the signing of his deposition. He is still within the period of time to sign his deposition. So, subject
You
to
want to
that
ask him
objection.
about that if he wishes to read and sign before he's asked about it?
Well, I think in fairness, Your Honor, if he certainly can look at the transcript, if he has amendments he'd like to make, he can take the time to tell us what they are. I would suggest maybe the best, most efficient way would be to do that passage by passage, rather than try to do the.
Well, I'm going to give the witness the opportunity to read whatever he's referred to, and if he wishes to make changes, I will allow him to do that. He has the right to do that within the time of reading and signing. My question is, do you have an objection about opening this and presenting it? All right. The record will reflect that I'm raising the seal on the document. And if you'll pass that to the witness for me, Mr. Clerk. Thank you very much. Greer, what you're being handed is the original, what appears to be the original of your deposition that was taken on the date that I indicated in October of this year. And that's being offered to you so that you can review the testimony. You may proceed, Mr. Tester.
Thank you, Your Honor. Mr. Greer, what I'd like to do is just direct your attention to page 99 of the transcript that's in front of you. And in particular, I'd like you to look at lines 7 through 12 of that transcript. Just let me know when we get there.
Excuse me, page 99 where?
Lines 7 through 12. It's on the screen. I don't know if that helps you any, but if you want to read it from the transcript there, that's also fine. And we appreciate, Mr. Greer, that you have now had the opportunity to review the transcript to see if you want to correct any errors in there, typographic errors or other errors.
What I'm going to ask you to do is refer him to the area you intended to ask about and then give him a chance to read it.
Okay.
Then ask him if he wishes to make any changes or correct.
So, Mr. Greer, if you look at the lines 7 through 12 in the deposition transcript, my first question then would be, once you have the chance to look at it, is there anything about that testimony that you would like to change?
I'm assuming you're asking me this question based on the response to your last question.
Correct.
And the answer I gave you to, I guess, your second question there in line 11 says, I think so because it helped me in my decision-making process. My answer to your question in this courtroom today is in no way contradicts that. I still, even though I may have information or gather information, I still am a man of my own and I make my own decisions based on what I know and believe and not on what someone else has told me. So as far as making any changes in this deposition, I would say it may have helped me, but it didn't change my mind one way or the other, neither yay nor nay.
And I'll move on to some other questions, Mr. Greer, and you may need to refer to that later, so you can keep it in front of you. Mr. Wilson, at some point in time, Mr. Greer, would you agree Mr. Wilson asked you to locate funds within the Anderson County budget to use for Mr. President's severance payout?
I would.
And when he asked you to do this, he told you to look for approximately $1.14 million, is that right?
I believe that's correct.
And once you were asked to do this, you went to Rita Davis in the County Finance Department, is that correct?
I think that's correct.
And you did this, made this request of the Finance Department within a day or two of Mr. Wilson's request to you, fair enough?
I couldn't tell you.
And I may have to show you a document, and I'm happy to do so, but do you remember that Ms. Davis had a memo that I showed you that had a date of November 3rd, 2008 on it?
I remember you showing that to me during the deposition, I believe.
Does that refresh your recollection that you would have been asking Ms. Davis about whether there was $1.14 million available in the budget around November 3rd, 2008?
I think when I spoke to Ms. Davis the first time, I asked her to provide me with budgetary information that would indicate the amounts left in various fund accounts.
And the reason you were asking her for that information was because you were looking to figure out if there was $1.14 million, give or take, that could support a severance payout to Mr. Preston. Fair enough?
That's correct,
And that happened on or about November 3rd.
according to that letter.
So as early as November 3rd of 2008, you knew that Mr. Wilson, as chair of the Personnel Committee, was looking for approximately $1.14 million in the county budget that might be used for a severance payout to Mr. Preston.
Evidently,
Before the November 18th meeting of County Council, you agree with me that Mr. Wilson provided you with a working copy of Mr. Preston's proposed severance agreement, right?
he did.
You don't remember when exactly you got that, do you?
No, I did not.
You agree with me that you never shared that working copy of the severance agreement with either Mr. Waldrop or Ms. Wilson?
You're gonna have to state your question again.
You would agree with me that you never shared that working copy of the severance agreement with Mr. Waldrop or Ms. Wilson, don't you?
I would agree with that.
And in fact, you disposed of that working copy of Mr. Preston's severance agreement before the November 18th meeting, correct?
I would say so.
Before the November 18, 2008 council meeting, you agreed that you talked with each of the other 4 members of county council who ended up voting with you in favor of the agreement, correct?
You're saying before November the 18th that I talked to each of the other 4 council members?
Right.
I did.
And you talked with each of them more than one time before the meeting occurred, correct?
Probably.
You did not talk with Ms. Wilson about the severance agreement in advance of the November 18th meeting, did you?
I did not.
And you did not talk with Mr. Waldrop about it either, did you?
I did not.
You were interested in knowing in advance of the November 18th meeting whether or not you had sufficient votes to approve the severance agreement for Mr. Preston, correct?
Yes.
And in fact, before the meeting started on November 18, 2008, because you had talked with the other 4 individuals who voted in favor of the agreement, you thought you had enough votes to pass it, didn't you?
I thought so, but was never sure.
Do you recall, well, let me ask it this way. Before the November 18, 2008 meeting, do you recall that it was mentioned between you and 1 or 2 other council members that you would be presenting the financial side of the severance agreement at the meeting?
That was part of one or more discussions.
And by you, it means Mr. Greer was going to be the person at the meeting that was going to present the financial side, correct?
That's correct.
And that was determined in advance of the meeting, fair enough?
Had to be.
Do you recall discussing having one of the county members raise a motion to reconsider so that you could prevent future reconsideration of the severance agreement?
State your question again, please.
Do you recall prior to the November 18th meeting happening that 1 or more of the county council members knew that they were going to raise a motion to reconsider so that you could prevent future reconsideration of the agreement?
Do I recall it?
Right.
No.
Before the meeting had occurred, before the November 18th meeting, you had discussed with Gracie Floyd that she would be the person to present the proposed contract to hire Mr. Cunningham to be the new county administrator, right?
To my recollection, she had requested to present it.
And would you agree with me that before the November 18th, 2008 meeting occurred, you had discussed that very thing with Ms. Floyd?
I don't know if it was a discussion, it's just a comment made that that's what she wanted to do, and that was the end of it.
You had no problem with Ms. Floyd being the person to present that proposed contract, did you?
No.
And that was something that was determined in advance of the November 18th meeting, correct?
I would say yes.
In fact, you were involved in 2 meetings before November 18th to discuss hiring Mr. Cunningham, weren't you?
Yes,
One of the meetings was at O'Charlie's in Greenwood.
that's correct.
And at that meeting, you, Mr. Wilson, Ms. Floyd, and Mr. Cunningham were all present, correct?
Mr. Wilson, Ms. Floyd, Mr. Cunningham, and myself, that's correct.
At that meeting, would you agree that you reached a consensus to hire Mr. Cunningham?
I'm sorry.
I'm sorry, I didn't ask that very well. Would you agree with me that at that meeting at O'Charlie's in Greenwood, the folks in attendance pretty much reached a consensus that Mr. Cunningham should be hired as the next county administrator?
I couldn't answer that.
Let me show you, if I can refer you to page 132 of your transcript that's in front of you. Just let me know when you get there.
All right?
If you look between lines 132, starting at line 9, actually, you can just start at the beginning of the page. Just to give you the opportunity to review that testimony. 132 and then 133 to line 12.
Okay, we're on page 132.
That's right, starting at line 1.
Line 1 going through what line?
133, line 12.
Okay, what's your question?
So the first question would be, now that you've had a chance to look at that portion of your deposition transcript, is there anything about that portion of the deposition transcript that you think is in error or should be corrected?
I think your question in the transcript was confusing
Okay.
because you've rolled what occurred in 2 meetings into one.
Okay, and I think I know what you're saying. Let me ask a a better question perhaps. Would you agree with me, Mr. Greer, that between the first and second meeting that you mentioned, where Mr. Cunningham was discussed, between the 2 of those meetings, at some point in time, a consensus was reached by the people at those meetings that Mr. Cunningham should be hired as the next county administrator?
At the conclusion of the second meeting, which was held at Ruby Tuesdays in Greenwood, where Mr. Wilson, myself, and Mr. Cunningham were present. I think a consensus was reached at that time, provided that the contractual parts were hammered out, that we had reached a consensus, yes.
And and I don't know which one, so you tell me, but at one of those meetings, would you agree that after the meeting was over, you provided or got Mr. Cunningham a copy of Mr. Preston's existing employment agreement?
I may have had one to give him, but I think he already had one, I'm not sure.
Would you agree that at some point, at or after those 2 meetings that you had discussing Mr. Cunningham came into possession of the agreement of Mr. Preston?
I would say he probably had one, yes.
And the reason for that was that you felt like it would be a good idea to use Mr. Preston's existing employment agreement as a model for the one to be proposed to Mr. Cunningham. Is that fair?
That's fair.
Would you agree with me that the contract that was ultimately offered to Mr. Cunningham at the November 18th meeting was a contract that was drafted by Mr. Tom Martin, county attorney, at the direction of Mr. Preston?
To the best of my knowledge, that's correct.
So it would be fair to say then that Mr. Preston knew that the contract for Mr. Cunningham was being prepared in advance of the November 18th meeting, correct?
That's
Objection,
correct.
Your Honor, calls for speculation.
I'll ask you to set a foundation for that knowledge.
He just said, Your Honor, his knowledge was that Mr. Martin prepared the contract at the direction of Mr. Preston.
But you're asking him to state what was in Mr. Preston's mind at that time, and I have not heard that he discussed that process with Mr. Preston and had some knowledge of what was in his mind at that time.
Let me ask.
So maybe you ought to rephrase the question as to whether he had knowledge of what was in Mr. Preston's mind. Yeah, that you can prove what people intend to do or what their knowledge is by circumstantial evidence.
Sir.
And then it's up to the finder of fact to draw inferences from that. And generally, I don't allow witnesses to testify as to what's in someone else's mind. They can testify about the facts and circumstances that existed at that time, from which me, the finder of fact, might be able to draw inferences. You understand my
Yes,
rule?
that's
All right, you may proceed.
So, Mr. Greer, if I'm understanding you correctly, you were aware that the contract for Mr. Cunningham, the one that was going to be proposed to him on November 18th, was being drafted by Mr. Martin at the direction of Mr. Preston.
That calls for hearsay, Your Honor. It may be being drafted by Mr. Martin, but unless this witness, he's asking this witness to testify about what Mr. Martin said that Mr. Preston told him to do.
I want to allow you to ask questions as to what Mr. Martin may have told Mr. Preston to do. Unless he was present. In some way, and observe what went on.
Let me try it a different way. Mr. Greer, did you understand that a contract to hire Mr. Cunningham was being drafted in advance of the November 18th meeting?
I was,
And who was drafting?
Mr. Martin.
And do you know how it was that Mr. Martin was asked to draft the contract?
I think he was, did I know how, Mr. Martin? Ask your question again.
Do you know how it came to be that Mr. Preston was asked to draft the contract for Mr. Cunningham?
Objection, Your Honor. I don't believe that those facts are in the evidence.
You
Mr. Preston.
misstated. You said that the contract was being drawn by Mr. Preston.
Yes, I did mistake.
You misstated, so and she caught you. So if you would re-ask the
A
question.
lot of names in my head. Mr. Greer, let me ask this the right way, I hope, and that is,
This is a tough process, but we're going to get through
Do
it.
you-
Go ahead.
do you know how it came to be that Mr. Martin was drafting the proposed contract for Mr. Cunningham? Or for Mr. Cunningham's employee?
I'm assuming, excuse me, I'm assuming he was asked to draft it by Mr. Cunningham.
And so you don't know one way or another how it came to be that Mr. Martin was drafting the contract. Is that fair?
You're asking me to recall things that happened 4 years ago.
Believe me, I'm not.
And I am doing my dead level best to answer you truthfully. I will say this, Mr. Martin was a county employee. Council members cannot instruct a county employee under home rule to do anything. An individual council member can't. It must be by a majority of council under home rule. So no council member could instruct Mr. Martin to do anything.
So based on that response, would it be fair for me to say that you knew no one on the personnel committee, none of the county council members instructing Mr. Martin to draft the contract for Mr. Cunningham, correct?
Objection calls for speculation, Your Honor.
I want to ask if he had knowledge of that. I'll allow that question. Go ahead.
Do I have knowledge if anyone on the personnel committee instructed Mr. Martin to do that?
Right.
Not that I'm aware of or recall.
And at the time, at that time frame, in November of 2008, in your view, who were the people who could instruct Mr. Martin to draft the contract? If not county council members, then who could do
The
it?
administrator.
And at some point in time, did you become aware that a contract for the proposed employment of Mr. Cunningham was actually drafted?
Yes,
How did you become aware of that?
it was handed to me.
By who?
I believe it was Mr. Cunningham, but I can't say for sure at this time.
Did you know when that was?
The night of November 18th.
And what did you do with the contract? This is a proposed contract now for Mr. Cunningham. What did you do with it when you received it?
It was in an envelope, filled up, and I handed it to Mrs. Floyd.
And is that because you had already talked to Ms. Floyd about the fact that she was going to be the person who would present that proposed contract?
She had requested it.
Mr. Greer, you would agree that every council member has the right to put any matters they wish on the agenda in advance of a county council meeting, correct?
Subject to approval by the chairman.
Okay. So would it be a better way to say it that every county council member has the right to suggest matters for the agenda to the chair?
The chair can approve or reject, and some were rejected at times.
So there's nothing to prevent you from asking the chair to put a matter on the agenda.
That's correct.
you could have asked, you personally could have asked Mr. Thompson to add consideration of Mr. Preston's severance agreement as an agenda item for a county council meeting, couldn't you?
I could.
And the restriction, if I understand it, tell me if I'm wrong, but the county council agenda has to be in, the way you guys did it, was the Friday before a Tuesday meeting. Is that-
No, sir, that's incorrect.
How much before a meeting do you have to have the agenda? for?
The items have to be presented to the council clerk by Wednesday, or did. I don't know how they operate now. But at that time, you had to have it to the council clerk by Wednesday so that she could prepare the agenda packets and have them delivered by Friday.
Would you agree with me, Mr. Greer, that there were upcoming county council meetings remaining on the calendar year of 2008, where you could have asked to put on the agenda in advance the fact that you were going to try to discuss Mr. Preston's severance agreement and Mr. Cunningham's proposed employment contract?
We could have.
In fact, there was a meeting to be held November 18th, 2008. That's the one at which it was considered, right?
That's correct.
There was also a meeting coming up on December the 2nd. Do you remember that?
I don't remember the dates. But they would have been, it was possible to have two in December, whatever the dates were.
In fact, what I'm going to do, if I showed you the meeting minutes for those meetings, would that refresh your recollection as to how many meetings were left in 2008?
I don't need to see the minutes. You had two, we had two per month, one on the first Tuesday, one on the third Tuesday.
Well, if I show you the meeting minutes, you'll actually see there were 3 left in December.
Yeah,
Which is
absolutely.
probably unusual.
3.
Let me show you, this might help you remember this. May I just approach Your Honor for refreshment of recollection purposes?
You may.
I think I've got it. Mr. Greer, I'm just going to show you just 3 cover pages. I've not marked this as an exhibit. I'll represent to you that those are the cover pages of meeting minutes for county council meetings in December of 2008, to see if that refreshes your memory as to how many county council meetings were left in 2008.
If you'll look at the third one, you evidently missed something, because the third one says special call meeting. That's not a regularly scheduled meeting. You don't have any knowledge that that's going to occur until approximately the time it occurs.
Okay, and that's a fair point. So there were only, based on looking at these documents, you would agree there were only 2 remaining county council meetings that were regularly scheduled
In December.
in December. In addition, it turns out that there was a 3rd meeting that was actually called at the very end of the month.
That's what it says.
And would you agree with me that you could have made an attempt to put the severance agreement of Mr. Preston and the employment agreement of Mr. Cunningham on the agenda for any one of those meetings, correct?
Usually when you have a special call meeting, you have to indicate what that meeting is for, and you can't deviate from it.
Okay.
So unless I was privy, and I don't know that I was, to the preparation of the agenda for that meeting, the answer could be no.
So at least for the 2 regularly called, the regularly scheduled ones, you could have tried to put these items on the agenda, fair enough?
That was possible.
Did you ever suggest to anyone that the decision on Mr. Preston's severance agreement and the decision on Mr. Cunningham's employment be postponed until one of those later meetings?
No.
Would you agree that it was not necessary for county council to hire Mr. Cunningham at the November 18th meeting?
No.
You don't agree?
No.
You think it was necessary?
Yes.
Do you agree that county council could have postponed the decision to hire Mr. Cunningham from the November 18th meeting?
Yes.
You would turn to page 147 of your transcript. This is a short section I would like to refer you to. Once you get there, it's from line 7 to line 14.
Line 7 and 14.
Right.
Okay.
And once you've had a chance to look at it, first just let me ask you, is there anything about that testimony that you think is incorrect or should be changed from what you said in your deposition?
Okay, in the deposition question, you asked, was it necessary from Anderson County's perspective? And I said that it was not necessary, and you said right, and I said, I don't guess it was necessary. No.
And would you still stand by that testimony today, that from the county's perspective at least, it was not necessary to hire Mr. Cunningham at that meeting?
It was not necessary, but my perspective was that it was necessary to ensure some continuity in the government of Anderson County. And so from my perspective, it was necessary.
Would you agree with me, Mr. Greer, that you could maintain continuity within the administration of Anderson County by simply hiring Mr. Cunningham as an interim administrator?
Like we have now?
Is that a yes?
I guess we could have, but we have an interim administrator that we've had for going on 4 years now.
Yeah, but and the point there I'm just making is, in terms of continuity, you still get continuity if you'd hired Mr. Cunningham as an interim administrator rather than hiring him permanently as administrator. Would you agree with that?
Could have. I wouldn't have recommended it. I don't think Mr. Cunningham would have accepted it.
And that's not the choice you made, correct?
No.
We earlier in the case saw a video of what happened at the county council meeting on November 18th. Would you agree with me, Mr. Greer, that you were not concerned with whether the way in which Mr. Preston's severance agreement was handled was fair to the two council members who voted against it? Would you agree with that?
You're going to state your question again and take a little more time.
I'm sorry, I'm going to ask it slower. I'm going to ask if you agree with this statement. Would you agree that you were not concerned with whether the way in which Mr. Preston's severance agreement was handled at the November 18th meeting was fair to the two council members who voted against it?
Let me answer you this way. I believe that my actions treated them just as fairly as I had been treated over the years that I served on council with them.
In my question, and I appreciate that response, the question is, you were not concerned with whether it was fair to those two council members, were you?
I think I was just as fair to them as they were to me.
Let me ask you to look at page 127 of your transcript. And if you look starting at line 13 through line 20,
I see that.
anything about that testimony you gave that was incorrectly recorded by the court reporter?
If I was going to answer it again after reflection, where I gave the answer, I think it was fair to them, my answer would be the same as it was today. I was just as fair to them as they've been to me.
And your answer in your deposition was, when I asked you if you thought it was fair, you said, quite honestly, I'm not concerned with whether it was fair to them or not. That was your answer, right?
And I would add to that because they never were concerned with how fair they were to me.
In November of 2008, would you agree with me that you did not know that the chair of county council, Mr. Thompson, had actually applied for a job in Anderson County?
Oh, no, we don't. State your question again.
In November of 2008, would you agree that you did not know that Mr. Thompson, county council chair, had applied for a job in Anderson County?
I would say I was not aware of that, yes.
You agree that Mr. Thompson did not tell you that, did he?
To the best of my recollection, no.
And you did not know that Mr. Thompson was taking appraisal courses in the fall of 2008 at county expense, correct?
I don't think I did, no.
You did not know that within days after your November 18th meeting, Mr. Thompson requested and received an advance from the county in the amount of $2,749.80 to continue taking appraisal courses into 2009, correct?
State your question.
It's a long question, I'm sorry. You agree that you did not know that within days of the November 18th meeting, Mr. Thompson requested and received a $2,700+ advance from the county to take appraisal courses into 2009.
at that time.
Right, you didn't know it at the time, did you? Is that correct?
That's correct.
You know that Al, I'm sorry,
Refresh my memory, what was the date of that event?
the
That you
advance,
just asked him about, what was
Yes.
that?
the date, there's different dates on it, Your Honor, but November 26th is a date that's stamped on it. Mr. Preston signed it, but couldn't say, as I recall, whether he signed it the day that it's
I just
stamped.
want to make sure I was thinking about the same one that you were asking.
And I can find it.
Just to clarify for me, you can go ahead.
You know that Miss Allison Shawn is the daughter of Ron Wilson,
Do I know that she is?
Right.
I do now.
and did you know that back in November of 2008?
I don't know that I did.
Did you know back in November of 2008, before you voted on Mr. Preston's severance agreement, that Ms. Shawn's company had a consulting contract with Anderson County that had been approved by Mr. Preston?
I had no firsthand knowledge of that.
Mr. Preston helped you raise money for your political campaigns in the past, didn't he?
He may have mentioned to some people that they might need to contribute, yes.
You're aware that in fact he did suggest to some people that they contribute to your campaign, correct?
I never heard it.
Did he tell you he suggested to people they contribute to your campaign?
Not that I recall.
Did you know that he was suggesting to people that they contribute to your campaign?
Objection, Your Honor, and that calls for speculation, because he's answered he didn't know. And then he's asking what he knows.
Hadn't been asked and answered, he said he didn't know.
Well,
Now, if there's a change in your question,
I was trying to get at the base of knowledge first. I went at it backwards. I thought he would answer differently based on his transcript, so I'm backing up now to try to establish, did he know, yes or no, and then how did he know?
well, let's try not to ask questions a couple of times. This is taking long enough, but I want you to fully present it. But once they ask a question, let's move on. Answer the question. Let's move on. Go ahead. I'll let you ask that question.
I'll just ask it this way. Do you agree with me that Mr. Preston suggested to some people that they contribute to your political campaign at any point in time?
He possibly did, yes.
In March of 2006, you were the chair of county council, correct?
2006. I don't remember the dates. I'd have to go back and look them up.
You were aware, let me ask it this way, you were aware of this Caters Lake incident that a lot of people in Anderson County know about?
Your Honor, the subject to our previous objections, I don't know if this is going to be a proper, but we have continuing objections to this line.
Your objections will continue. You may proceed subject to your objections.
Would you agree that you presided over a county council meeting in March of 2006 where the Caters Lake incident was discussed?
I think I did, yes.
And a presentation was made at that council meeting by Deputy Chief Boucher about the incident at Caters Lake, right?
Sheriff Crenshaw and the deputy.
And in addition, a statement was given to council by Mr. Preston about what happened at Caters Lake. Is that
I
correct?
think that's correct.
Did you have any first-hand knowledge of any kind of undercover operation, such as the one described by Mr. Boucher and Mr. Preston at that meeting?
What do you mean by first-hand knowledge?
Like, did you personally know of any such undercover operation?
No.
In your mind, is it important that the county administrator tell the truth to county council?
I would say yes.
And if it were proven that a county administrator, or if it was proven that your county administrator had a improper relationship with a county employee during your tenure on county council, you would agree that that would be grounds for termination, correct?
If it was termination based on the contract under which he was employed.
Do you recall, if you look at page 177 of your transcript, I'm going to direct your attention to 177, line 20, through 178, line 9.
line what now?
I'm sorry, 177, line 20, through 178, line 9.
Okay. Now what's the question?
Is there anything about the testimony as transcribed in your deposition transcript that you think was incorrectly transcribed or in error?
Not incorrectly transcribed, but after further reflection and thinking back to the contract, I've said if it could be proven, but I would have to also amend that answer by stating if it could be proven that it was a violation of his contract. And I think his contract says he has to be convicted of moral, what's the word I'm looking for?
Crime of moral turpitude.
Moral turpitude.
Does the contract also include a provision that says the county administrator has to obey the Constitution and laws of South Carolina as part of his duties?
I don't recall that.
Let me just finish by asking, Your Honor, I think we've got an agreement with respect to Plaintiff Exhibit 33, which is a transcript of a portion of the March 21st, 2006 County Council meeting, that we can offer this. It is subject to the standing objections that they have. I don't intend to ask any other questions about it. I just want to offer it this time.
It'll be again subject to your objection. Put on the list of challenged evidence like the other matters that we
With that, Mr. Greer, I thank you for your time. Please answer any questions. Attorneys for Mr. Preston.
Okay, so excuse me. No problem. You may proceed.
Thank you, Your Honor.
Yes, ma'am.
Mr. Greer, I'm going to ask you a first question while I'm standing over here so that I can make sure that
Would you excuse me just a moment, please? All right.
I apologize. I'm going to ask you a question first while I have my deposition in front of me. Would you go back to page 127 of your deposition and the question that Mr. Tessier asked you about, and you said that had you thought about it with regard to the fairness, you might answer differently. Can you read what your answer was when you answered Mr. Tessier's question, lines 22 through the next page, line 2?
127, line 22 through
The
Line
next page
2.
on line 2, yes, sir.
because they weren't concerned about being fair to me and other council members as they pursued their course of action. When Mr. Waller stood in the meeting in Tylerville and made the statement, "Boss Hogg is dead, we're getting on things I had, we're done."
And who was he talking about when he was talking about Boss Hogg?
Me.
He referred to you as that?
That was the implication of what he said, yes, ma'am.
Now, let's talk about a couple other things. You talked about the way that you make decisions. Can you tell me about your deliberative decision-making process?
My deliberative decision-making process is that I'm a listener. I recall one of the first meetings that I attended as a newly elected council member in '99 was in our efforts to deal with Santee Cooper. And at that meeting, Mr. Preston sat in on the meeting, and we were meeting with two representatives from Santee Cooper. And Mr. Preston, through facial expressions and body language, seemed concerned that I wasn't saying much. But my deliberative process is that I'm a listener. I listen carefully to what's being said, and then I form my opinions and my actions based on what I've heard in my course of actions.
Are you a person who rubber stamps things?
No, ma'am.
And when Mr. Bright came to talk to the Personnel Committee, let's talk a little bit about that. When was that Personnel Committee appointed?
I believe that Personnel Committee was appointed, initially, I think Mr. Waller appointed that Personnel Committee the previous council year. And then I think when Mr. Thompson took office, he reappointed the committee.
And under your rules for council, when would that have occurred?
Should have been in January.
of 2008,
of 2008.
long before the primary registration in March of 2008.
Yes, ma'am.
Long before the primary happened in June of 2008.
Yes, ma'am.
And it's your testimony that Mr. Thompson just continued the committee appointments of the prior chair, Bob Walter.
I'm not sure if it was the same makeup because I don't recall what the makeup of the committee was the year before. But that was the committee that was established under Mr. Thompson.
In your 10 years on county council, had a personnel committee ever had to deal with a matter of the weight and magnitude that the severance and anticipatory breach of contract claim and the tort claims alleged were?
Not to my knowledge.
Now, I want to talk to you a little bit about some of the other issues in this case. Who else was on the personnel committee with you again?
Mr. Wilson and Mr. McAbee.
Do you recall in 2007 that one of the priorities of the council that they set was to promote sustainable agriculture in Anderson County?
I think that was done in one of the workshops or whatever that we had.
And that process, if I understand it correctly, is that the council, do you want some water?
I'm fine.
Okay. That the council has a workshop and a working session, and you all set what your goals are for the county to instruct the county administrator how you want him to prioritize his time and the county's resources over the next year.
That's correct.
And when you all set that priority for sustainable agriculture back in 2007, did you expect Mr. Preston to act on those goals and priorities of the council?
Sure we did.
And are you aware in 2007, in an effort to act on those priorities of the council, that Mr. Preston contracted with a contractor to help consult with them about promoting sustainable agriculture in Anderson County?
I'm not aware that it occurred in that time frame.
Were you present at a meeting where Ms. Wilson raised a complaint about a contractor who was an agricultural consultant?
I vaguely remember her raising that issue at some point in time.
And if the minutes reflected that at the time she complained about that, she stated on the record in the minutes that Allison Sham was Mr. Wilson's daughter, would you have any reason to dispute that?
Ask me that question again.
Sure, I'm sorry, it was a little bit long. If the minutes reflected at that time when Ms. Wilson raised the concerns about this agricultural consulting, that she brought up Allison's relationship to Mr. Wilson, would you have any reason to dispute that?
I'm going to try to be as polite as I can.
Yes, sir.
I question anything that Miss Wilson tells me.
Okay, fair enough. And you don't listen to that radio program, do you?
Absolutely not.
So if it was on that radio program too that Ms. Shawn was Mr. Wilson's daughter, you wouldn't have known that either.
No.
Now, if you had known that Allison Shawn had gotten a contract, were you aware of the Sustainable Agricultural Conference that occurred at the end of October in 2008?
The one that was held at the Civic Center?
Yes, sir.
Yes. In fact, I talked with Mr. Wilson concerning sustainable agriculture, and I thought that it was a good thing and was supportive of it.
And in your capacity as a council member, did you deem that conference that occurred over the course of the last weekend in October of 2008 a success?
As far as I know, it was, yes.
And if the contract for Ms. Shawn was executed the very day after that contract or that conference ended, do you think that would be inappropriate?
Not necessarily, no.
And had you known that that contract had been executed, and had you known of this relationship between Ms. Shawn and Mr. Wilson, would that have changed your vote on November 18th?
No.
Now, you, up until the time of the severance and thereafter, you haven't had a business relationship with Mr. Preston, have you?
Other than selling him hay for his donkey.
How many times have you sold him hay for Cindy Lou?
Probably 2 or 3 times.
How much did he charge for hay?
I charge him what I charge everybody else.
Did he buy hay from you before November 18th of 2008?
I think he did.
All right. And did his buying hay for Cindy Lou in any way affect your vote on November 18th of 2008?
Absolutely not.
You know, we're going to stipulate the hate transaction.
I appreciate you willing to do so, and I would accept stipulation. You may proceed.
Did you receive any personal benefit in exchange for your vote on Joey Preston's severance?
No.
And in fact, it's been quite the contrary, hasn't it?
It's costing me somewhere between $3,000 and $8,000 to be here today.
What were you supposed to be doing instead?
I should be in New York on a storm response team at this time.
And I apologize, sir. With regard to November 18th of 2008, do you recall if there was any items on the agenda already that dealt with the employment of Mr. Preston?
Yes, there was.
And I'm going to show you what's been pre-admitted and marked as Plaintiff's Exhibit 4. When they correct, Sherman.
Yes, ma'am.
Can you tell me the item on the agenda that you believe could have covered or given the public notice of severance regarding Mr. Preston?
Item 16 on page 2 of the agenda reads, discussion of the authority of county council to employ the administrator was placed on the agenda by Mr. Bob Walter, requested 10 minutes, and he was allotted 10 minutes.
And as a council member, if you put something on the agenda about what you have in mind that you want to pass, did it always come out the way you wanted it to come out?
No, it can be actually, and it has been at times, taken over by another council member and proceed with and run with.
Now, when you were talking amongst the personnel committee, let's go back to one of the questions that Mr. Tessier asked you. I believe he showed you the notes from Mr. Bright, thank you, about your conversation with Mr. Bright on the 13th of October of 2008. Do you have those?
Yes, I do.
Now, Mr. Bright called you prior to the first personnel committee meeting, is that correct?
I'm not sure if he called me before then or after.
Okay, I'm gonna give you something else maybe that'll help.
I don't have the date fixed in my mind, so if you're asking me before or after, I can't answer truthfully.
I'm going to show you what's been pre-marked Defendant's Exhibit 70. These are 2 agendas for 2 personnel committee meetings. Does that help refresh your recollection, sir, about the personnel committee meeting dates?
All right, the first one was on October the 27th, so if Mr. Bright's notes are correct, then he did call me before the first meeting.
And were you made aware by him that he was calling other members of council as well?
I was.
Now, up until the time of the severance vote, what had the votes on council been for things that were favored by you and Mr. Wilson and Mr. Thompson?
Mr. Waldrop and Ms. Wilson, if you probably check the record, would historically oppose most of it.
And so how many votes would there normally be in favor of things you wanted versus things that Ms. Wilson and Mr. Walker wanted?
Usually, well, it takes 4, 5 actually, to have a successful vote. So if it was successful, it was 5, and if it wasn't, it was 4. But I do remember one item in particular that I pushed very strongly, and I still feel very strongly about it. I feel like Anderson County is being unfair to its citizens, and it should be changed. And that is that in the ordinances, there is a section that deals with changing road right-of-ways. And I pushed to have that changed so that they didn't take citizens' property without compensation. And when we went into the vote on that, I had 5 votes. I had counted them. When we voted, I only had 4.
So things changed.
Things changed.
Going into the meeting on November 18th of 2008, did you know for sure that all of your colleagues were going to vote in favor of this severance?
You don't know for sure until they raise their hand.
And when things start being discussed amongst individual council members, is there anything illegal about one council member going and lobbying another council member?
No,
Is there anything illegal if that council member goes and lobbies a third council member?
no.
And in fact, it's only illegal when those parties are together if there's either A, a quorum of the council, which is 4 or more members, right? Is that correct?
That's correct.
Or B, if you're on a committee, all members of the committee, right?
The county code says that a minimum of 3 is required for a quorum of a committee.
All right. So if, say, you and Mr. Wilson were meeting with Ms. Floyd to talk to Mr. Cunningham, that wouldn't be a quorum of the personnel committee, would it, sir?
No, ma'am, it would not.
And the consensus that you all had about the fact that Michael Cunningham could be hired as the county administrator, subject to working out the details of his contract, were also subject to the council approving Mr. Preston's severance, right?
It was all contingent upon that, yes.
And had the severance not been approved, then Mr. Cunningham's hiring would actually violate Mr. Preston's contract, wouldn't it?
It would.
Now, with regard to the incidents, I'm going to show you, Mr. Tessier asked you about the termination of the cause provision. I'm going to show you what's been marked as Plaintiff's Exhibit 1 and ask you if you see anything in here that says about a general compliance with the state constitution, or is it subject to the duties as outlined in paragraph 1 of the contract, which are the duties under home rule?
Okay, now ask me your question again, please.
Sure. Mr. Tessier, I think asked you, didn't Mr. President also have to comply with the general laws and the Constitution of the state of South Carolina? Or that could be a breach. But in that provision, isn't that subject to in discussing the duties as set forth in paragraph 1 of the contract, which are the duties as set out in the home rule?
That would be my understanding and interpretation. It says that compliance with the laws and Constitution of the state of South Carolina and performance of duties set forth in section 1 of this agreement.
And when you, I'm sorry, go ahead.
And basically it's saying that he's got to comply with the code of laws of South Carolina.
All right. Now, when you talked about, let's talk about what you knew on November 18th of 2008. Y'all had personnel committee meetings leading up to that, right?
That's correct.
And Mr. Bright was he came to both of those personnel committees that I gave you the agendas for. Is that correct?
That's correct.
And y'all weren't trying to keep Mr. Wilson or Ms. Wilson and Mr. Walter out by having this meeting up in Powdersville, were you?
No.
And in fact, in the government building that's owned by Anderson County that was up in Powdersville, isn't it not even a half mile from Mr. Wilson's office?
It's almost within walking distance.
And Mr. Bright's office is up in Greenville, is that correct?
It was closer for him.
Y'all paying Mr. Bright by the hour?
I would assume so. Most of you work by the hour.
We're a dangerous lot with that. And
At least my check where I paid you for the last time shows it by the hour.
thank you, sir. With regard to the meeting y'all had up there, you and Mr. McAbee traveled up there for that meeting, right?
That's correct.
And then the next meeting y'all had was in the courthouse across the street, right?
That's correct.
Now, at these personnel committee meetings, were you all inquiring to Mr. Bright about the legitimacy of the anticipatory breach claim and what the options were for the county to resolve it?
We discussed those options and the anticipatory breach, yes.
Did you specifically question Mr. Bright with regard to his analysis under the Coward decision?
We discussed it somewhat, and based on what I had read in the South Carolina Code of Laws, and I did pull them up sometime previous and read some of these, and what I knew about the Powdersville administrators thing, I felt that Mr. Bright did not have, this is my opinion, that he did not have a full and thorough understanding of the differences between an administrator's contract and position and that of an administrator of a water utility.
Why did you believe there was a difference?
In my opinion, there was a very big difference. As Mr. Tessier said in my deposition, I'm not an attorney, but I do read. And the home rule says that an administrator can be employed by a contract for years, plural. It does not say 1 year, 2 years, or 3 years. It just simply says plural. The Powdersville administrator, to my knowledge, is not covered in the Code of Laws through the contractual thing. And it's my understanding that the contract that the Powdersville administrator had was a lengthy contract. I believe I've heard the term 20 years plus. So there was a big difference between that and what would be a contract for an administrator of a county government.
And when Mr. Bright provided you advice as reflected in a memorandum we pre-admitted Defendants Exhibit 8, I'll let you review that. 28, I'm sorry, if you want to review that. But when Mr. Bright met with you all, gave you all legal advice as reflected in that memorandum, did he give you one option or a number of options?
This list that you provided, there are several options.
And were there other options that he didn't provide?
There was one option on there that was overlooked. Yes, ma'am.
And what option was that?
If you'll go back and read Mr. Preston's contract, there is a clause in there that states that if council votes to not renew his contract, that his contract is not renewed and his contract would expire at the end of the non-renewed term,
And so
or something to that effect.
I'm going to show you what's been marked as Defendants Exhibit 1 on page 2 under term. Is that the provision you're talking about? Yes, sir.
The last paragraph D, yes, ma'am.
And did Mr. Bright give you all that option or explain that to you?
He never mentioned.
And did that weigh into how much weight you gave some of his proposals versus the others?
Yes, it did.
Did the fact that you felt he misunderstood the Coward exception, did that weigh into the weight that you gave some of his recommendations versus others?
It did.
And ultimately, did you go through a deliberate decision-making process before you voted on November 18th?
I most certainly did.
Did you go through a deliberative decision-making process when determining how much you felt the claims that Mr. Preston was asserting and could assert before deciding how much you thought the county should pay Mr. Preston to divorce him?
Okay, I think I've got your question, and I'm gonna try to answer it. If I
Sure.
mixed it up a little bit, we can rehash it.
No problem.
Based on the discussions that we had, it was my belief that it was cheaper to buy out Mr. Preston's contract in the manner in which we did than it was to do nothing and let the events flow as I perceived that they would. It's my opinion then, and it's my opinion now. And that was part of my decision-making process, that what we did that night and what we voted on saved the people of Anderson County in excess of $1 million. However, that has long gone by the wayside. So I hope that's the answer to your question.
Did you at any time when you voted November 18th of 2008 ever conceive that the county would have undertaken the investigation at the cost they did?
I knew, at least I thought I knew, that they would be unhappy. I never dreamed that our elected leaders of Anderson County would be so foolish as to squander away the amount of taxpayer money that they have in pursuit of this.
Are you a Republican?
I ran as a Republican.
Objection.
Next question, I'll skip that one. Are you a fiscal conservative?
Yes, ma'am.
And do you believe that what you did on November 18th was being a good fiscal steward of Anderson County's
I
money?
do.
Do you still believe that today?
I do. And I've had citizens relate that belief to me as well.
And with regard to the negotiation that was occurring, do you recall the first demand from Mr. Preston as communicated to you through Mr. Breyer?
I'm not sure if it was through Mr. Bright or someone else, but the first number I heard was 1.9, I believe it was,
$1 million.
$1 million.
And you were aware that Mr. Preston had an ongoing lawsuit going on with Ms. Wilson and Mr. Waldrop at that time when the severance also was going on.
I was.
And if you would, if I may approach you on it.
You may.
In Exhibit 1, which is the master agreement. Now, you said you've read this a few times. Are you aware that if the severance, it's item E on page 4, that contemporaneously with the delivery of all severance pay and entitlements herein set above, the administrator agrees to execute and deliver to the county a release releasing the county of all further claims that the administrator may have against the county. And then that paragraph ends after that. Were you aware of that, sir?
I was.
And are you aware that in the severance agreement, that in exchange for the monies paid to Mr. Preston, that he agreed also to relieve the council members individually of any and all claims that he had against council members individually, including Mr. Waldrop and Ms. Wilson?
I believe that's correct.
Now, did Mr. Preston have any claims against you on November 18th of 2008?
Not that I'm aware of.
He hadn't threatened to sue you for anything, or wasn't suing you for
No.
anything, was he? Was he threatening to sue Mr. McAbee, or was he suing Mr. McAbee for anything?
I don't know. Have no knowledge of that.
Did you have any knowledge if he was suing or threatening to sue Mr. Wilson for anything?
No.
Do you have any knowledge if he was suing or threatening to sue Ms. Floyd for anything?
No.
Do you have any knowledge if he had sued or was threatening to sue Mr. Thompson for anything?
No.
Now, you're aware that Mr. McAbee, when there was a fee in lieu voted on for Lincoln Energy and the Lewis Road closure, that Mr. McAbee recused himself from those votes. Do you recall that?
I do.
And I'm going to show you what's marked as Defendants 58. And I want to talk to you a little bit about that process. When Mr. McAbee recused himself during those votes, what did he do?
He made the statement that he had, now this is as best I recall,
Yes, sir.
but he made a statement, something to the effect that he was recusing himself and he had delivered a recusal to the council clerk.
And at that point,
And then he left the room.
okay. Is that the procedure that was operated under during your time on council?
That's what's supposed to happen.
And on November 18th of 2008, despite the fact that Mr. Waldrop and Ms. Wilson would be released by the settlement agreement for their own tort claims, did they file anything with the clerk?
Not to my knowledge.
Did they say that they were going to recuse themselves?
No, they did not.
Did they leave the room or stay in the room?
No, they did not leave the room.
And did they participate in the debate?
Yes, they did.
And in your time on council, with regard to conflict of interest, do you believe that that was correct for them to do?
Based on what I know, if they had an involvement in it, they should have recused themselves and left the room.
Now, Mr. Tessier asked you about the incoming council members-elect and asked you about the election that was coming up. I believe your testimony was that you were absolutely sure that those council members would win election in November of 2008. Do you recall that?
I think I said something. In fact, there was no doubt in my mind.
Was there any doubt in your mind when you voted on the severance that the new council would come in and do everything that Mr. Waldrop stated at the audit committee meeting in August of 2008?
Total speculation, Your Honor,
I asked his perception.
of what someone else might do in the future.
What is, can you state, what is his perception or his understanding of the situation? What's it? I'll take it for what it's worth. You may proceed.
Okay, ask me your question again, please.
Sure. Did you have any doubt in your mind that when the new council took office in January of 2009, that they would do anything but what Mr. Waldrop said they were going to do in August of 2008 at that audit committee meeting?
I firmly believe that they would.
Objections noted, you may proceed. You can answer the questions.
I firmly believe that they would do what Mr. Waldrop had stated at that meeting at the, I believe it was held at the county museum. And that was confirmed by the letter that was delivered where Mr. Waldrop and Ms. Wilson and the three council members elected, working in unison, had asked the administrator to freeze 25 positions. So I think that confirmed my suspicions and my perceptions.
And that happened the day before the severance vote, didn't
I think that letter was dated November 17th.
it? Now, I'm going to ask you a couple questions, and Your Honor, this is subject to the proffer because the proffer's out there.
All right, subject to your prior objections, you may proceed.
And Mr. Greer, you've had the opportunity, I think, to review the minutes from the March 21st, 2006 county council meeting where the sheriff and Mr. Boucher appeared and Mr. Preston made a statement
Yes.
to the council. After reviewing those minutes, at any time was Mr. Preston asked if he was having a relationship with Ms. Nichols at this meeting?
No. Not that I recall.
Rereading today, and you actually went further, as I understand in this meeting, and that you actually contacted the city chief of police in addition to taking information from the sheriff and Mr. Boucher, right?
I did.
And sitting here today, do you still have any knowledge that what was told to you on March 21st of 2006 was in any way incorrect?
I have nothing to say different.
And even if sitting here today, you found out that Mr. Preston in fact had a relationship with an employee, that issue was never raised on March 21st of 2006 during that meeting, was it?
No.
Now, with regard to the severance agreement, let me ask one more question actually before we go there. Prior to March 21st of 2006, were you as a council member and other council members receiving written hateful letters?
Yes, ma'am.
And I'm going to show you a document which has been pre-marked as, found my notes here. Defendants Exhibit 133, and ask you if you recognize this document.
Yes, I do.
Can you tell me what that document is, sir?
Would you state that again, please?
Can you tell me what that document is?
It's, I'd call it a hate letter. It's a letter basically threatening, accusing that immoral acts are going to be performed on my person, that my financial accounts are being examined, and it's very threatening.
And what did you do with that letter?
It ended up at the sheriff's office
And why did it end up at the sheriff's office?
because in my opinion, it was criminal in nature, and that's where it belonged, and it should be pursued and investigated.
Your Honor, I would move to admit that into evidence at this time as Defendants Exhibit 138.
Our same objections as before, hearsay and relevant.
Hearsay is to,
This is a letter from an anonymous person signed the investigator in March 2006, and no one has ever established who this person is.
And, Your Honor, we're not
what is being
admitting,
offered for?
it's being offered to show that he was receiving letters, not that someone would actually bugger him or sodomize him.
All right, objections overruled on that basis. Pass the exhibit up, I'd like to see it. Thank you. Make sure.
And at the same time frame as March of 2006, did that continue through a period that lasted throughout the time you were on council, with you and other council members receiving hateful letters, hateful phone calls, things like that?
We received those letters on more than one occasion. It got to the point that I could recognize them before ever opening the envelope. And I remember that I received one, handled it very carefully, and asked for a meeting with Sheriff Crenshaw. I think Deputy Boucher was there. And I believe Mr. Dees, who is no longer with us, was there when we met with Sheriff Crenshaw and Deputy Boucher. And I carried the unopened letter to the sheriff's office and asked them to open it and see if they could secure any type of identification from the letter.
And at that time, Mr. Dees was also a council member?
Yes, ma'am.
And in your capacity as a council member, on or about February of 2008, did you receive a copy of that letter from the chairman, Mr. Thompson, to the sheriff, Sheriff David Crenshaw?
What number is that?
138. That's the one I thought I introduced yesterday with Mr. McAfee.
This is 136.
I'm sorry, 136.
Did I receive it?
Yes, sir.
I would say yes, I did.
And do you recall the substance of the complaints in the letter that Mr. Thompson was talking about during council meetings?
The one thing I remember is that he referred to the fact that he was threatened to be sodomized, that he needed to check his homeowner's insurance policy. I remember that he was referring to the very threatening nature of those letters that were received.
And Your Honor, this time I would move to put defendant's exhibit 136 into evidence.
Same objection.
Objections noted, I assume it's being offered for the same purpose.
Yes, Your Honor.
It's admitted.
Not as the pre-marked.
Thank you. That's marked.
Now, on the backdrop of this harassment, these harassing letters, did that weigh in any way in your decision to vote for the severance on November 18th of 2008?
Did my having received those letters weigh into the decision-making process?
The culture that was created by the harassing letters, the harassing nature, and the dispute that had gone on in this county for 5 to 10 years at that point.
Let me see if I can answer you this way.
Sure.
I felt like it was time to put an end to it. I felt like it was time for Mr. Preston to move on. And I also felt that he should be treated fairly and equitably. And that would not have been those letters would not have been an item that would have caused me to sway one way or the other, but it would have been something that would have concerned me.
And was there any reason to prolong the agony of this dispute further past November 18th, despite the fact that you had 2 more meetings coming up?
No.
In your mind, did you do the right thing on November 18th of 2008?
Yes, ma'am.
I want to ask you just a couple more little specific questions, and then I'll be done with you. Now, you said that the county attorney worked for the county over here and not directly for the council members. Now, that included the deputy county administrator. Is that correct?
Yes.
And did the deputy county administrator often directly work with the county attorney on this?
I'm assuming so.
You don't have any knowledge to the contrary?
No, I don't.
And when you all were in the personnel committee meetings and you all were talking about the severance, were you communicating with Mr. Bright about what your thoughts were as far as what was an amount you could live with in a severance?
Mr. Bright.
Well, with Mr. Bright, with your co-personnel committee members, were y'all talking about the amount?
The amount was, the amount was discussed at some point in time. Now, who I discussed it with, I'm not sure. It could have been Mr. Wilson, could have been Mr. Bright, or it could have been both. I know I made it known very early that I was totally opposed to 1.9. In fact, if you'll check the depositions or whatever, I've answered something to the effect that I wanted it to be less than $1 million.
And you don't know, sitting here today, if Mr. Bright then communicated that to Mr. Preston's legal team to try to negotiate the number down, do you?
I don't know what he communicated to them.
You don't know if Mr. Bright was telling Mr. Preston's legal team, I'm having problems getting 2 council members to give me the amount you want as a negotiating strategy, do you?
I don't know that he did or didn't.
Had you known that Mr. Thompson was seeking employment with the county, would that have affected your vote on November 18th of 2008?
No.
Had you known that Mr. Thompson was receiving appraisal courses at the cost of the county, would that have affected your vote on November 18th of 2008?
No.
Thank you, Mr. Perry. I'm sorry for the inconvenience we have cost you and the money we cost you to leave. Please answer any further questions that Mr. Tessier has or the judge directs.
Redirect. You may proceed.
Thank you, Your Honor.
Mr. Greer, what I heard you say is that you just wanted to treat Mr. Preston fairly and equitably, is that right?
That's correct.
It didn't matter to you whether or not he had any legitimate anticipatory breach claim, did it?
Yes, it did, and I thought he did.
You agree that you paid, the severance amount that you paid to Mr. Preston, you agree was in excess of any amount that he was entitled to under his employment agreement, correct?
No, I was not.
You think there's a provision in his employment agreement that provided for him to receive?
I think my answer says it fairly and equitably. And to me, fairly and equitably, we had cost, or not we, but this whole matter had cost him employment possibilities. And I felt like the settlement that we had finally settled on was a fair and equitable settlement.
You agree that the $350,000 plus that the county paid to Mr. Preston to purchase him retirement service credits is not an amount that is called for under his employment agreement, correct?
I understand that it's not what's called for, but if he were to seek damages, then that would have been part of the damages. And in an effort to avoid further litigation, I thought that was an appropriate action to take.
And you're not here to tell anyone that you believe it was appropriate to pay Mr. Preston any sum of money based on the political culture of Anderson County, are you?
I'm not sure I understand what you mean.
Well, we heard a lot of talk about how the political culture in Anderson County was toxic and people were being harassed, right?
Right.
You're not suggesting that Mr. Preston should have received any amount of money because there was harassment going on in the county, are you?
I think that's what led us to the point where we were at.
And so you think it was justifiable to pay Mr. Preston money
I
based
didn't
on?
say that.
That's what I'm asking. Do you think it would be justifiable to pay him any money based on the political culture of Anderson County?
Your Honor, I believe this has been answered twice.
This will be the last time. Which one is best?
Okay, ask me again.
Are you trying to tell us that it would be appropriate in your mind to pay Mr. Preston any amount of money as part of his severance agreement because you're considering the fact that the political culture of Anderson County is toxic?
The political culture in Anderson County is toxic, and that's part of what led us to the point where we're at.
And wouldn't that same argument apply to anyone else who is working under the same political environment at the same time? In other words, we could pay Mr. Cunningham based on that as well, or Ms. Wilson, because she was going back and forth with Mr. Preston about the same type of thing.
There's a difference between the instigator and the receiver.
So you took Mr. Preston's side, in other words.
No, sir. I took the right side.
Let me ask you about Caters Lake real quick. That incident involved Mr. Preston being seen at Caters Lake with Kelly Nichols, correct?
I'm sorry.
The incident at Caters Lake that was discussed at the March 21st County Council meeting involved Mr. Preston being seen at Caters Lake with Kelly Nichols, correct?
I'm not sure that I ever had it confirmed that he was there with Kelly Nichols. I couldn't answer it.
Did you know that he was seen there with a female county employee at least that much?
I'm not sure that it was a female employee. I don't know.
You asked a lot of questions of various law enforcement officers about what happened at Caters Lake, correct?
I did.
And you never determined what he was seen there doing and with whom?
No.
You talked about the fact that you believe Mr. Waldrop and Ms. Wilson should have recused themselves from voting on the severance agreement. Is that what you believe?
Yes, sir, I do.
Let me just make sure I understand this. You had a working copy in advance of the November 18th meeting of the severance agreement, correct?
At some point in time.
And so you had time to figure out all the provisions of that agreement, right?
No.
You had some amount of time before the meeting, at least, to review the working copy, didn't you?
I had time to review the working copy.
And you chose not to share the working copy with Mr. Wilson or Mr. Waldrop, right?
Miss Wilson and Mr. Pollard.
I'm sorry, yes, Ms. Wilson and Mr. Waldrop. Did you share the working copy with Mr. Wilson? Did you share the working copy with Mr. Wilson? That's who you got it from, right?
Yes.
And what about Mr. Thompson?
No.
You destroyed the working copy that you had, correct?
Yes.
And at the meeting, would you agree that that's the first time that Ms. Wilson and Mr. Waldrop had any opportunity to look at the provisions of the severance agreement that they'd be voting on?
That's the first time they've seen it, to my knowledge.
And so they would have to decide in the short time that they had it, whether or not that provision affected them personally, right?
Yes,
And they asked for legal opinions about the seventh speaker, didn't they, at the meeting?
I don't recall.
And in the end, would you agree Mr. Waldron and Ms. Wilson voted against the severance agreement, right?
Yes,
So they voted against this provision that you're talking about that would supposedly protect them from tort claims, right?
yes.
They voted against their interest. Would you
No, they
agree?
voted against the severance agreement.
You voted in favor of the severance agreement, right?
That's correct.
So you voted in favor of a provision that would release you from tort claims, correct?
Yes,
Last thing to ask you is this. You testified, and I think I heard you right, you can't count votes in advance, right?
you try, but you can't actually do it.
There's no way to tell what's gonna happen until they raise their hand at the meeting, right?
That's correct.
So it's all up in the air until the vote happens.
Yes.
Mr. Preston was making a claim of anticipatory breach, right?
Yes,
He was predicting what might happen to him in January of 2009, correct?
ask me your question again.
Mr. Preston was predicting that something was gonna happen to him in January of 2009, right?
He was predicting something was going to happen based on actions that had taken place, yes.
Just like you do, you predict what a vote's gonna be like when you try to count the votes in advance, right?
Right,
And you don't know for sure though until it actually happens.
right.
And based on that prediction of what might happen in January 2009, you voted in favor of paying over $1 million of Anderson County money to Mr. Preston, right?
Yep.
That's all I have to thank you.
Yes, ma'am.
Super caution, real short.
Okay.
And I'll stand right here. Mr.
I'm gonna try to
Greer.
get through on this witness before 1 o'clock. We've got 10 minutes.
Thank you.
Go ahead.
Mr. Greer, would you agree that Mr. Waldrop and Ms. Wilson and the rest of the council knew that Mr. Preston had claims against Mr. Waldrop and Ms. Wilson since they were served with that lawsuit back in August?
Objection, asking what other people knew.
Was it public knowledge
Thank you.
that Mr. Preston had sued Mr. Waldrop and Ms. Wilson personally back in August of 2008?
I would say yes, because just like I had to be here today, because Mr. Davis's office and Mr. Tessier's office served papers on me. So I would assume that they were aware of it.
You got a copy of those papers as a council member from Mr. Preston, didn't you? All council members did.
I probably did, yes.
And the ordinance that talks about voting under a conflict of interest, does it say voting in your benefit or against your benefit, or does it say vote, period?
It says something to the effect, you shouldn't vote if you have an interest in the matter.
And it wouldn't matter if you're voting against your interest or for your interest. If your interest is at stake, it just says vote, right?
That's correct.
Thank you. I have no further questions.
All right, so you may step down.
Your Honor, we have no problem excusing the witness from
Any objection?
No objection.
Sir, I'm going to release you from the subpoena. You're no longer required to be present. I will caution you, I've issued an order in this case requiring that witnesses not discuss their testimony with anyone, either before, during, or after their testimony. So it would be a violation of that order if you discuss your testimony before the case is beginning. Do you understand?
I do.
All right, you're free to go. Thank you very much.
Mr. Greer, would you bring my exhibits with you, please, sir?
I'm not sure who.